Friends, in this video, we will quickly revise Indian polity, all the important concepts for Prelims 2024. This video will be of approximately 1.5 hours to 2 hours. So let's start. First, we will see the formation of Indian Constitution, the historical background for the demand of Constituent Assembly. The first such demand was raised by M.N. Roy, who was the pioneer communist, and he put forward the idea of Constituent Assembly for India in the year 1934. After that, Indian National Congress first time officially demanded a Constituent Assembly in 1935. In 1938, Jawaharlal Nehru declared that the constitution must be framed without outside interference by a constituent assembly elected on the basis of adult franchise. In 1940, British accepted this demand through August offer and also in the subsequent offer by Cripps Mission in 1942, which was rejected by Muslim League. Now, we will see the formation of Constituent Assembly. So, the Constituent Assembly was constituted in November 1946 under the Cabinet Mission Plan. It was to be a partly elected and partly nominated body with members indirectly elected by the provincial assemblies on a limited franchise. The success of our constitution is also because of the representation that was provided from all the sections of the society, whether it was Hindus, Muslims, Sikhs, Parsis, Anglo-Indians, Indian Christians, scheduled caste, scheduled tribe. Every section of the society was given representation in the Constituent Assembly. The first meeting of the assembly was held on December 9, 1946, with the Muslim League boycotting it. Dr. Sajidanand Sinha was made the temporary president following the French practice, and then Rajendra Prasad was elected as the president on December 11, 1946. Now we will see key events and milestones. So on December 13, 1946, Jawaharlal Nehru moved the historic objective resolution, which inspired our current preamble, and it outlined the philosophy and structure of the constitution. The resolution was adopted on January 22, 1947. The Mountbatten Plan of June 3, 1947 led to the Indian Independence Act of 1947, which made the Constituent Assembly a fully sovereign body and also a legislative body, which acted like a first parliament until our first election happened in 1951. Adoption of national symbols followed this sequence. National flag was adopted first on July 22, 1947, then national song on January 24, 1950, and Dr. Rajendra Prasad as the first president on January 24, 1950. The final constitution adopted on November 26, 1949 contained a preamble, 22 parts, 395 articles, and 8 schedules. Some of the provisions came into force immediately, while the rest became effective on January 26, 1950. There were major committees. The first and the foremost committee was Drafting Committee, which was set up on August 29, 1947. This committee was chaired by Dr. B.R. Ambedkar and included N. Gopalaswamy Iyengar, Alladi Krishnaswamy Iyer, Dr. K.M. Munshi, Sayyid Muhammad Sadaullah, N. Madhav Rao, and T.T. Krishnamachari. Other important committees and their president are Steering Committee by Dr. Rajendra Prasad, Union Powers Committee by Jawaharlal Nehru, Union Constitution Committee by Jawaharlal Nehru, and Provincial Constitution Committee by Sardar Vallabhbhai Patel. Now we will see salient features of the constitution. It is the lengthiest written constitution. It draws inspiration from various sources. It is blend of rigidity and flexibility, and it is a federal system having unitary bias. Other key feature is parliamentary form of government and a synthesis of parliamentary sovereignty as well as judicial supremacy. So parliamentary sovereignty was taken from British system and the principle of judicial supremacy from the American system, amalgamation of both. Integrated and independent judiciary, single citizenship. Now we will see some of the sources of the constitution. So the Government of India Act of 1935, the constitution borrowed following features: federal scheme, office of governor, judiciary, public service commission, emergency provisions, and administrative details. From British constitution, parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative rights, parliamentary privileges, and bicameralism. From US Constitution, fundamental rights, independence of judiciary, judicial overview, impeachment of the president, removal of Supreme Court and High Court judges, and post of vice president. From other constitutions like Directive Principle of State Policy from Ireland, Concurrent List from Australia, Suspension of Fundamental Rights during Emergency from Weimar Germany constitution, fundamental duties and ideals of justice, liberty, equality, and fraternity from France and Soviet Union, and procedure for amendment and election, from South Africa and Japan, which are not that important. Okay. Now we will see the preamble. So, the preamble to the Indian Constitution is based on the objective resolution drafted by Pandit Jawaharlal Nehru, and the preamble has been amended only once in 1976 by 42nd Constitutional Amendment, which added the words socialist, secular, and integrity. The American Constitution was the first to begin with the preamble, and this concept was adopted by the framers of the Indian Constitution. Okay. Keywords in the preamble we will see. Sovereign means implies that India is an independent state free to conduct its own affairs, both internal and external. Second keyword is socialist. So refers to the Indian brand of democratic socialism, which holds faith in a mixed economy where both public and private sector coexist side by side. Third is secular. Added by the 42nd Constitutional Amendment Act of 1976, it represents a positive concept of secularism where all religions have the same status and support from the state. And the fourth is democratic, refers to the doctrine of popular sovereignty where the people possess supreme power either directly as in Switzerland or indirectly as in India. Then justice. The ideal of justice comprises social, economic, and political, has been taken from the Russian Revolution of 1917. Then liberty. Liberty means the absence of restraints on the activities of individuals and providing opportunities for the development of individual personalities. The preamble sources to all citizens of India liberty of thought, expression, belief, faith, and worship. Then equality. Equality refers to the absence of special privileges to any section of the society and the provision of adequate opportunities for all individuals without any discrimination. Then fraternity. Fraternity means a sense of brotherhood, assuring the dignity of the individual and the unity and integrity of the nation. The word integrity was added to the preamble by the 42nd Constitutional Amendment. The status and amendability of the preamble. So, the preamble is an integral part of the Constitution as established by the Supreme Court in the Keswanand Bharati case 1973 and the LIC of India case 1995. It is non-justiciable. The provision of the preamble are not enforceable in court of law. It is neither a source of power to the legislature nor a prohibition upon the powers of the legislature. Then amendable. The preamble can be amended subject to the condition that no amendment is done to the basic features. The fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 368. It contains the republic and democratic principles, okay, and reflects the mind of constitution maker, guides constitutional interpretation, outlines fundamental principles, and shapes democratic ideals. See fundamental duties. So fundamental duties were inspired by the USSR Constitution and they were inserted through the 42nd Constitutional Amendment Act of 1976 based on the recommendation of Swaran Singh Committee. These duties are confined to citizens only and are non-justiciable, meaning they cannot be enforced by law without legislative provisions. Verma Committee was also one of the inspiration behind fundamental duties. Now, one by one, we will see the fundamental duties. The first is respecting national flag and anthem. Second is to follow noble ideals that inspired the national struggle for freedom. The third is to protect unity and integrity of the nation. The fourth is to defend the country and render national service when called upon to do so. The fifth is to promote brotherhood, transcending religious, linguistic, and regional or sectional diversity. The sixth is to preserve rich heritage of the nation. The seventh is to protect the environment, including forests, lakes, rivers, and wildlife. The next is to have a scientific temper, humanism, and spirit of inquiry and reform. Then citizen must safeguard public property and abjure violence. The next is that citizens should strive towards excellence in all sphere of individual and collective activity so that the nation constantly rises to higher level of endeavor and achievement. The next is was added through 86th Constitutional Amendment Act of 2002 that citizens who are parents or guardians should provide opportunities for education to their children or wards between the age of 6 to 14. Now we'll see basic structure doctrine. So through a series of judicial pronouncement, this basic structure doctrine came. In Shankari Prasad case 1951, the Supreme Court held that the power to amend the constitution also means amendment to fundamental rights. However, in Golaknath case, the Supreme Court reiterated that fundamental rights are transcendental and immutable, and Parliament cannot abridge or take away any of these rights. However, in Keshavanand Bharati case, it overruled the Golaknath judgment and upheld the validity of the 24th Constitutional Amendment Act, while also laying down the doctrine of basic structure. So, what is basic structure? So, basic structures are the foundations of constitution. The Keshavanand Bharati case identified several essential features that form the basis of the constitution or the basic structure of the constitution, which cannot be amended or abridged by the parliament. These include supremacy of the constitution, judicial review, sovereign democratic and republican nature, freedom and dignity of the individual, secular character, parliamentary system, rule of law, separation of power, fundamental rights, welfare state, constitutional supremacy, democratic values, etc. etc. Now we will see fundamental rights in the Indian Constitution. So first of all, what are the features of fundamental rights? Applicability of fundamental rights are available only to citizens, while some are applicable to citizens, some are also applicable to everyone, whether they are citizen or not. They are also applicable for the foreigners. Okay, so it has been divided into two parts in terms of applicability. Second is, fundamental rights are not absolute. The state can impose reasonable restrictions on them. The third feature is that fundamental rights are justiciable, meaning they cannot be enforced through the court. They can be enforced through the courts against arbitrary state action. Agar there is a arbitrary state action, then it can be enforced through the courts. The fourth feature is amendability. Fundamental rights are not sacrosanct. They can be curtailed or repealed by the parliament through a constitutional amendment act, but not by an ordinary act. Now we will see the one by one fundamental rights in brief. The first is Article 14. It guarantees equality before the law and equal protection of the law, ensuring the absence of special privileges and the equal subjection of all persons to the ordinary law. The next is Article 15. It prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. It also allows for special provisions for women, children, socially and educationally backward classes, and economically weaker section. The next is Article 16. It provides for equality of opportunity in public employment, prohibiting discrimination on grounds of religion, race, caste, sex, descent, place of birth, or residence, with exception for residence requirement and reservation for backward classes. The Article 17 abolishes untouchability and prohibits the practice, while Article 18 abolishes title and prohibits their acceptance or conferment except for the military or academic distinctions. The next is Article 19. It guarantees freedom to all citizens: freedom of speech and expression, peaceful assembly, forming associations or unions, movement throughout India, residence and settlement, and profession. The next is Article 20. It provides protection against ex post facto laws, double jeopardy, and self-incrimination in criminal proceedings. The next is Article 21. It protects the right to life and personal liberty, including the right to live with human dignity, privacy, education. It requires a fair and reasonable procedure for deprivation of these rights. The next is Article 22. It grants protection against arbitrary arrest and detention, including the right to be informed of ground for arrest, consult a lawyer, and be produced before a magistrate within 24 hours. Article 23 is also known as the right against exploitation. It prohibits traffic in human beings and forced labor with exception for compulsory public service. Article 24 prohibits employment of children below 14 years in factories, mines, or hazardous activity. Now, right to freedom of religion, it includes Article 25 to Article 28. Article 25 says it guarantees freedom of conscience and right to freely profess, practice, and propagate religion for all persons. Article 26 grants religious groups the right to establish and maintain institutions, manage their own affairs, acquire property, and administer it according to law. Article 27 prohibits compelling any person to pay taxes for the promotion or maintenance of any particular religion. Article 28 prohibits religious instruction in educational institutions wholly maintained by state funds, with exception for institution established under endowment or trust. Now, cultural and educational right. Article 29 protects the interest of minorities by allowing them to conserve their distinct language, script, and culture, and prohibits discrimination in admission to state-funded educational institution. Then there is Article 30, which grants minorities the right to establish and administer educational institution of their choice. The next is Article 32, which is also known as right to constitutional remedy. It empowers the Supreme Court to issue writs for the enforcement of fundamental rights, considered a basic feature of the Constitution. Exception is that President can suspend the right to move any court for fundamental rights during a national emergency, and Parliament can empower other courts to issue writs. The scope is Article 32 is used solely for the enforcement of fundamental rights, not other legal rights or remedies. Now we will see directive principle of state policy in the Indian Constitution. So the directive principle of state policy are a set of guidelines enshrined in Part 4 of the Indian Constitution from Article 36 to 51. These principles aim to guide the state in formulating policies and enacting laws for the welfare of the people. The DPSP embody the concept of welfare state and are non-justiciable in nature, meaning they cannot be enforced by the courts. However, they serve as a moral guide for governance and help the judiciary determine the constitutional validity of laws. They are classified based on socialist and Gandhian and welfarist principles. Okay, liberal intellectual principle to be precise. So first we will see socialist principles which are guiding certain directive principle of state policy. So there are mainly three. The first is equal pay for equal work, which is mentioned in Article 39. Then second is protection of workers, which is mentioned in Article 39 and 42, which says that ensuring just and human working condition and providing maternity relief. The third is cooperative society. Article 43b promotes the voluntary formation, autonomous functioning, democratic control, and professional management of cooperative society. Now, directives based on Gandhian principle. The first is village panchayat. Article 40 aims to establish village panchayats as units of self-government, promoting decentralization and grassroots democracy. The next is cottage industry. So Article 43 encourages the promotion of cottage industry on an individual or cooperative basis in rural areas, supporting traditional crafts and local economies. The next is Article 46, which mandates the promotion of educational and economic interest of scheduled castes, scheduled tribes, and other weaker section of society. Now, directive principle based on liberal intellectual principles. The list is long. The first is Uniform Civil Code. Article 44 calls for the state to endeavor to secure a uniform civil code throughout the territory of India, promoting a common set of laws for all citizens. The second is early childhood care and education, which is enshrined in Article 45. The third is modern agriculture and animal husbandry, which is enshrined in Article 48. Environmental protection, which is enshrined in Article 48A. And preserving of historical monuments, which are given in Article 49, and separation of judiciary and executive, Article 50. Now, amendments to the directive principle. So 42nd Amendment Act of 1976 introduced Article 39A, which is free legal aid, 43A, worker participation in management, and 48A, environment protection. Then 44th Amendment Act 1978 mandated minimizing economic inequalities among groups and eliminated the right to property from fundamental rights. Then 86th Amendment Act 2002 mandated elementary education of fundamental right under Article 21A. These are not part of DPSP. DPSP has been amended by 42nd and 44th Amendment Act. Certain times there have been conflict between fundamental rights and DPSP, like in Champakai Dorai Rajan versus State of Madras case. Ruling was fundamental rights prevail over DPSP in case of conflict. In Golaknath versus State of Punjab 1967, it was said that fundamental rights cannot be amended by Parliament for implementing directive principles. In Keswanand Bharati versus State of Kerala 1973, it was said Parliament can amend any part of the Constitution but cannot alter its basic structure. And it was reiterated in Minerva Mill versus Union of India case 1980. How implementation of directive principle is done? So Indian government has implemented various acts and programs to fulfill the DPSP, such as land reform, labor reform, Panchayati Raj system, promotion of cottage industry, education initiative, rural area development, health programs, environmental protection, and heritage preservation. The significance is that it acts as a moral compass for the governance, instrumental in reforms, shaping socio-economic policy, and adapting to evolving needs. In this video, we will try to revise Parliament chapter of Lakshmikant, which is extremely important, and we will see all the important points that can be asked in the examination. So, first of all, the Parliament is the legislative organ of the Government of India, and it was inspired from the British Westminster model. The part 5 of the Indian Constitution deals with the Parliament, the organization of Parliament, the composition, duration, officers, procedures, privileges, and power of Parliament. That is from Article 79 to Article 122. The organization of Parliament includes the President, Lok Sabha, which is also known as House of the People or Lower House, and the Rajya Sabha, which is also known as Council of States or Upper House. Though the President is not a member of either House of the Parliament, but he can prorogue both the houses. Lok Sabha has a maximum strength of 550 members. 530 come from states, 20 come from union territories, and 2 can be nominated member. The ratio of seats to population must be maintained, and delimitation is done after each census. Whereas in Rajya Sabha, the maximum strength is 250 members, and 238 comes from states and union territories, and 12 are nominated members representing literature, art, science, and social service. Members are elected through a system of proportional representation with a single transferable vote. There is also provision of reservation of seats. The Constitution has abandoned the system of communal representation. Initially, seats were reserved for scheduled caste and scheduled tribe for 10 years, but this has been extended periodically. The 95th Amendment Act extended the reservation until 2020, which was further extended. Lok Sabha the criteria is that minimum age to contest the election should be 25 years. The tenure is 5 years, and he must be a citizen of India. In Rajya Sabha, the minimum age is 30 years, the tenure is 6 years, with 1/3 retiring every 2 years. Now we will see how a member of parliament can be disqualified. Members can be disqualified mainly on 3 grounds. One is office of profit, second is anti-defection law, and third is the other miscellaneous grounds. So, office of profit is members holding certain government positions are considered to have an office of profit and must resign from one of the offices. It wants to establish a kind of compartmentalization between the executive and legislature. However, the definition of office of profit is nowhere mentioned in the Constitution of India. The second is anti-defection law. Members can be disqualified for defying the party whip if party has issued a whip, or except in cases of mergers or expulsion, this anti-defection does not work. So a kind of wholesale defection is still allowed. Other grounds are if a person is of unsound mind, insolvent, and corruption are also grounds for disqualification. In Representation of People's Act, if you are convicted for a crime and got a punishment for more than 2 years, you will be disqualified. All these provisions are there for the disqualification of members. Now, what if you have double membership? So, members elected to both houses must vacate their seat in the Rajya Sabha within 10 days. If a sitting member of one house is elected to the other, their seat in the first house becomes vacant. Members elected to both parliament as well as state legislature must vacate their parliamentary seat within 14 days. Okay? Now we will see about the presiding officers. The first is Speaker of Lok Sabha. He is elected by the Lok Sabha, and Speaker is the head and principal spokesperson of the houses. The Speaker decides on disqualification of members as well as interprets the Constitution and maintains order and decorum, and his decision is also final in money bill. Then there is Deputy Speaker. He is elected by the Lok Sabha. The Deputy Speaker presides over the House in the absence of the Speaker and can cast a tie-breaking vote. The Deputy Speaker also presides over joint sittings in the absence of the Speaker. You need to remember that if at all a Speaker of Lok Sabha is present, Deputy Speaker is just like an ordinary member. And the Speaker of Lok Sabha can only have a casting vote. That you also need to remember. Then comes the Chairman of Rajya Sabha. The Vice President of India is the ex officio Chairman of the Rajya Sabha. The Chairman's power and functions are similar to those of Speaker, except for deciding on money bills and presiding over joint sitting. Joint sitting कौन preside करेगा? That will be presided by the Speaker only. Now we will see the sessions of the Parliament. The President summons each House of Parliament with a maximum gap of 6 months. This is mentioned in the Constitution. Okay, exact wording. These are typical. There are typically 3 sessions. Okay, each year: the budget session, the monsoon session, and the winter session. So the budget session happens between February to May. Monsoon session happens from July to September. Winter session happens from November to December. Okay. The President can also terminate a session or dissolve the Lok Sabha. The power is with the President. Okay. Now we will see certain parliamentary proceedings. The parliamentary proceedings involves various devices, including the question hour, 0 hour, motions, and discussions. What is question hour? The first hour of every sitting is reserved for members to ask questions and minister to provide answers. Okay. The next is 0 hour. Okay. The hour after question hour is used to raise matters of urgent public importance. जैसे ही क्वेश्चन आवर खत्म होगा 0 आवर स्टार्ट हो जाएगा. फिर आता है मोशंस. So motions are proposal for discussion and decision on various matters, including censure motion हो सकता है ना, no confidence motion हो सकता है ना, censure motion, no confidence motion and adjournment motion. ठीक है. तो ये होते क्या है? सेंसर मोशन होता क्या है? सेंसर मोशन और नो कॉन्फिडेंस मोशन में एक सटल डिफरेंस है. देखिए, सेंसर मोशन जब आप अडॉप्ट कर रहे हैं तो द रीजन फॉर द अडॉप्शन ऑफ सेंसर मोशन इन दी लोकसभा मस्ट बी स्टेटेड. रीजन आपको बताना पड़ेगा. नो कॉन्फिडेंस मोशन जो होता है, नो रीजन फॉर इट्स अडॉप्शन मस्ट बी स्टेटेड इन दी लोकसभा. दूसरी बात यह है, द सेंसर मोशन कैन बी पास्ड अगेंस्ट एन इंडिविजुअल मिनिस्टर or a group of minister or the entire council of minister. However, a no confidence motion can be passed against the entire council of ministers only. Censure motion is moved for censoring the council of ministers for specific policies and motions. However, no confidence motion is moved for ascertaining the confidence of the Lok Sabha in the council of ministers. ठीक है. सेंसर मोशन अगर पास हो गया तो नो वन फ्रॉम द काउंसिल ऑफ मिनिस्टर्स नीड्स टू रिजाइन इफ द मोशन इज पास्ड इन द पार्लियामेंट. हाउएवर, नो कॉन्फिडेंस मोशन इफ इट इज पास्ड इन द लोकसभा, द एंटायर मिनिस्ट्री इंक्लूडिंग द प्राइम मिनिस्टर मस्ट रिजाइन फ्रॉम द ऑफिस. Okay, and Article 75 of the Constitution of India states that the Council of Ministers is collectively responsible to the Lok Sabha as long as it enjoys the confidence of a majority of the members of the houses. Okay, that you need to remember. This difference is extremely important and you need to understand it. Okay, and then there are several discussions that happens in the parliament. Okay, like short duration discussion, special mentions are used to deliberate on issues of public importance. Also, adjournment motion involves an element of censure against the government that you need to remember. Therefore, Rajya Sabha is not permitted to make use of this device. This is an important part. Now we will see types of bill. So there are mainly four types of bill. One is ordinary, second is money, third is financial, and fourth is constitutional amendment bill. So what is the ordinary bill? So ordinary bill is can be introduced in either houses and must pass through 3 readings in each house before receiving the presidential assent. Okay. Money bill, on the other hand, can only be introduced in the Lok Sabha and cannot be amended or rejected by the Rajya Sabha. The Rajya Sabha can only make recommendations which the Lok Sabha may or may not accept. The next is financial bills. So financial bills involves expenditure from the consolidated fund of the India and are treated as ordinary bill except for certain provisions that are treated as money bill. Now we will see the constitutional amendment bill. So a bill for the amendment of the constitution can be introduced only in either house of the parliament, okay, not in the state legislature, first thing. Second is the bill can be introduced either by a minister or by a private member and does not require prior permission of the president. The bill must be passed in each house by a special majority, that is majority more than 50% of the total membership of the house and a majority of 2/3 of the members of the house present and voting. This you need to remember. Each house must pass the bill separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses. If the bill seeks to amend the federal provisions of the constitution, it must also be ratified by the legislatures of the half of the states by a simple majority. Okay. The president must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for reconsideration of the parliament. After the president's assent, the bill becomes an act, a constitutional amendment act, and the constitution stands amended as per the changes made by the act. Okay. Now we will see the joint session of parliament. The president can call for a joint session of both houses to resolve a deadlock in the passage of a bill. This can occur if the bill is rejected by one house, if the house disagrees on amendment, or if the bill has not been passed by one house within 6 months of receiving it. So the thing is, bill is rejected, disagreement or on amendments, delay in passage, the speaker of the Lok Sabha presides over joint session, and if the house still disagrees, the view of the Lok Sabha prevails. This you need to remember. Now we will see the budget process. So in constitution, budget word is not mentioned. It is the annual financial statement. Is a statement of the estimated receipts and expenditure of the government of India for the upcoming financial year. The first step is presentation. The finance minister presents the budget in parliament. Then the second is general discussion. A general discussion on the budget takes place in both houses. Third is scrutiny by the various committees. Okay. Then comes the voting on demands. Both houses vote on the demands for grants. The final step is appropriation and finance bill. The appropriation bill and the finance bill are passed to give effect to the budget. Okay. Now we will also see different kinds of motions are there. There are different kinds of cut motions. Okay, which is not given in this slide, but I want to remind you. So there are mainly 3 types of cut motion. The first is disapproval of policy cut, which seeks to reduce the amount of demand to ₹1, representing the disapproval of the policy undermining the demand. Second is economy cut. The economy cut motion calls for a reduction in the allocation of the demand to a specific amount. And third is token cut. A token cut motion is moved so that the amount of the demand is reduced by ₹100. This is to ventilate a specific grievances that is within the sphere of the responsibility of the government of India. Okay. This also you need to remember. Now there is multifunctional role of parliament. It also has legislative power, can make laws on subject in the union, state under certain circumstances, and concurrent list. It also has financial power. Parliament approves the budget, imposes taxes, and controls government expenditure. It has constitutional power. Parliament can amend the constitution through various procedures, including simple majorities, special majority, and ratification by states. And then it has judicial power. Parliament can impeach the president, vice president, judges of the Supreme Court, High Court, and other constitutional authorities. Now, position of Rajya Sabha compared to Lok Sabha. So equal power कहाँ है राज्यसभा का? Ordinary and constitutional amendment bills में, elections and impeachment of the president and vice president में, approval of ordinances and proclamation of emergencies में, consideration of reports from constitutional bodies में. Special power कहाँ है लोकसभा का? Introduction and passage of money bills में, revocation of proclamation of emergency में, passing a no confidence motion में against the government, presiding over joint sessions of parliament में. Now we will see parliamentary privileges. So member of parliament enjoy certain privileges to ensure their independence and effective functioning. एक होता है individual privileges. So individual privileges होते हैं freedom from arrest during sessions and 40 days before and after. Second is freedom of speech and vote given in parliament. A collective privileges है right to punish for contempt of parliament. Second is exclusion of courts from inquiring into proceedings of parliament. Okay. Now we had studied about the special powers of Rajya Sabha. Now we will see different types of parliamentary funds. There are mainly three types of fund: consolidated, contingency, and public account. So consolidated fund of India is all revenues received by the government of India, loans raised, and money received in repayment of loans are credited to this fund. No money can be withdrawn from this fund without the approval of the parliament. Second is contingency fund. This fund, held by the finance secretary on behalf of the president, is used to meet unforeseen expenditure when the parliament is not in session. And third is public accounts fund. This fund holds all public money other than those credited to the consolidated fund of India, such as provident fund, judicial deposits, and departmental deposit. So with this we have covered all the important things of the parliament chapter, and I hope this will be helpful for you to revise important things. Take care, best wishes. Commission which gave certain recommendations which are important. The first recommendation was the commission recommended establishing a permanent interstate council to facilitate coordination between the center and state. The second was it suggested that the president rule article 356 should be used only in extreme and rare cases, and that the armed forces should not be deployed in states without their consent except in cases of external aggression. The third is strengthening all India service. The commission proposed strengthening the all India services to maintain national standards and promote cooperative federalism. The fourth important provision was that it recommended implementing the three-language formula in education and requiring the center to consult states before enacting laws on the concurrent list. The next important committee was Punch Commission, which was established in 2007. It gave certain recommendations like the commission emphasized the importance of cooperative federalism and unity, building upon the Sarkaria Commission report. Second, the commission suggested that the governors should not serve as chancellors of university, and that the procedure for their impeachment should be same as that of the president. Third was the regarding appointment of governors. It recommended that governors should be appointed based on the Sarkaria Commission guidelines, be from outside the state, and not be eligible for any office of profit. Governors could be appointed for a second term. It proposed creating new All India service to meet emerging needs and setting up an interstate trade and commerce commission. Now we will see national emergency. So what are the grounds for declaration? The president can declare a national emergency on the grounds of war, external aggression, or armed rebellion, previously known as internal disturbance. The second is it requires parliamentary approval. So the proclamation of national emergency must be approved by both houses of parliament within 1 month and can be extended indefinitely with parliamentary approval every 6 months. The third is effects on center-state relation. So during a national emergency, the center can give executive direction to the state on any matter, make laws on any subject, and modify the distribution of revenues. The fourth is effect on fundamental rights. So fundamental rights under Article 19 are automatically suspended, and the President can suspend the enforcement of other fundamental rights except Article 20 and 21. Now we will see President rule. So the grounds are the failure of constitutional machinery in a state or non-compliance with central directives. Second is it requires parliamentary approval, must be approved by both houses of parliament within 2 months. Consequences is that the president can take over the functions of the state government, exercise legislative power, and suspend constitutional provisions. In terms of judicial review, the satisfaction of the president is in invoking Article 356 is subject to judicial review, and there are certain guidelines which are given in the SR Bombay case. Now we will see financial emergency. The grounds is the president can proclaim a financial emergency if the financial stability or credit of India is threatened. It requires parliamentary approval. The proclamation must be approved by both houses of parliament within 2 months and continues indefinitely until revoked. The effect is the center can extend its executive authority over states' financial matters, reduce salaries and allowances, and reserve money bills for the president's recommendation. There are certain criticism of emergency provisions, like state power could be concentrated in the hands of union executive, the federal character may be destroyed, the financial autonomy of states could be nullified, etc. etc. Dr. Ambedkar acknowledged the possibility of the emergency provisions being misused or employed for political purpose. Now, historical instances of emergency declaration. The first time in 1962, the first proclamation of national emergency was issued due to the Chinese aggression in the NEFA and remained in force until January 1968. Second time in 1971, the proclamation of national emergency was made in December 1971 in the wake of the attack by Pakistan. In 1975, the third proclamation of national emergency was made in June 1975. Even though the second one was still in operation, it was most controversial instance of emergency declaration. Both were revoked in March 1977. Now we will see evolution of Panchayati Raj and scheduled areas in India. So the first committee was established for Panchayati Raj establishment in Balwant Rai Mehta committee in 1957. It recommended a 3-tier Panchayati Raj system. Then Ashok Mehta committee in 1977, it recommended a 2-tier Panchayati Raj system, and GVK Rao again 2-tier Panchayati Raj system. To go in detail, you need to revise Lakshmikant if you want to go in detail, because there are many provisions which are given in these committees. Okay, I am again giving you certain provisions which are extremely important. Like in Dantewala committee, it recommended block level planning. You have to remember. In Hanumantarao committee, it recommended district level planning. In LM Singhvi committee, it recommended the revitalization of the Panchayati Raj system. In Thangan committee, which was established in 1988, recommended a 3-tier Panchayati Raj system. In Gadgil committee, again a 3-tier Panchayati Raj system. Now, these all formalized through 73rd Constitutional Amendment Act in 1992. The 73rd Amendment Act of 1992 added a new Part 9 to the Constitution of India, titled the Panchayats, consisting of provisions from Article 243 to 243O. The Act established the following key features. The first was Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system, consisting of all registered voters in the area of Panchayat at the village level. The second is it establishes a 3-tier system. The Act provides for a 3-tier system of Panchayati Raj in every state at the village, intermediate and district level. The third is the Act mandates direct election for all members of Panchayats and provides for the reservation of seats for scheduled caste, scheduled tribe and women. The duration of Panchayat is the Act provides for a 5-year term for Panchayats at every level with provision of dissolution and fresh election. Disqualifications is the Act outlines disqualification for being a member of a Panchayat based on state laws and age criteria. The Act establishes also a State Election Commission to oversee the preparation of electoral rolls and conduct of Panchayat election. Now we will see scheduled and tribal areas. So declaration of scheduled area is by the President. The President is empowered to declare an area scheduled area and alter its boundaries as well. The executive power of a state extends to the scheduled areas, with the governor having a special responsibility. The governor can direct the applicability or modification of laws in scheduled areas. The 6th schedule contains provision for the administration of tribal area in certain states. Okay, Assam, Meghalaya, Tripura, Mizoram. Now we will see What is fifth schedule? Deals with the administration and control of scheduled areas, scheduled tribes in any state except Assam, Meghalaya, Tripura and Mizoram. Sixth schedule deals with the administration of tribal areas in the four northeastern states of Assam, Meghalaya, Tripura and Mizoram. Ladakh is also demanding. Governor की पावर क्या है इसमें? The governor can organize and reorganize autonomous districts, increase or decrease their areas and change their names. Then applicability of law. Acts of parliament or state legislature may or may not apply with modification in autonomous districts and regions. Now we will see doctrine of judicial review. So what is judicial review? So judicial review is the power of judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state government. It is crucial mechanism for ensuring the supremacy of the constitution and safeguarding the rights and liberties of citizens. The Indian Constitution, though it does not explicitly mention the phrase judicial review, provides the legal basis for this power through various provisions like Article 13, 32, 226 and other empowers the Supreme Court and High Court to review the constitutionality of laws and executive actions, particularly in relation to the protection of fundamental rights. Okay. Compared to United States, the scope of judicial review in India is somewhat narrow, as the Indian Constitution adopts the principle of procedure established by law instead of due process of law. Though in Menka Gandhi case, it was established that also the due process of law can be established for specifically Article 21 of the Indian Constitution. Now we will see judicial review and the evolvement of 9th schedule. The Supreme Court ruled that the laws placed in the 9th schedule after April 24, 1973 are open to challenges in court if they violate fundamental rights or the basic structure of the constitution. Significant departure from the early position, okay, because first Constitutional Amendment Act of 1951 established 9th schedule with the intention of shielding certain laws from judicial review on the ground of contravening fundamental rights. However, the Supreme Court landmark judgment in I.R. Coelho case significantly eroded this blanket immunity as well. The court held that judicial review is a basic feature of the constitution and cannot be taken away even by placing a law under 9th schedule. We had studied the doctrine of basic structure, and I.R. Coelho case also made it from this doctrine. It said that building on the basic structure doctrine, the Supreme Court in the case affirmed that laws placed in 9th schedule are still subject to judicial review. Okay. The next is the governor, which is extremely important this year. So first is what are the constitutional provisions? So appointment of governor. Article 153 states that there shall be a governor for each state appointed by the president. One person can serve as governor for 2 or more states as well. Dual role. The governor acts as the constitutional head of the state, bound by the advice of the Council of Ministers, and act as a vital link between the union and state governance. Eligibility. As per Article 157 and 158, a governor must be citizen of India, at least 35 years old, not a member of parliament or state legislature, and not hold any office of profit. Term. The governor term is normally 5 years but can be terminated earlier by dismissal by the president on the advice of the Council of Ministers or by resignation. It is given in Article 156. Historical background. So under the Government of India Act 1935, governors were appointed by and served the interest of British Raj. The Constituent Assembly initially proposed elected governors, but concerns about potential clashes with CM led to the system of appointed governors. The 1948 draft constitution was ambivalent on whether governors should be elected or nominated. Now recommendation. S.R. Bommai judgment 1994 defined the instances of failure of constitutional machinery and allowed judicial scrutiny of the material on which the president's satisfaction regarding such failure is based. Nabam Rebia judgment 2016 ruled that the governor's discretion under Article 163 is limited and should not be arbitrary or fanciful. Then Administrative Reform Commission 1968 recommended that governors' report regarding president rules should be objective and based on their own judgment. Rajmannar Committee 1971 says recommended the deletion of Article 356 and 357 and emphasized that the governor should not act as an agent of the center. Sarkaria Commission 1988 stated that the Article 356 should be used sparingly and only as a last resort after issuing a warning to the state government. We will see types of writs in India. The first is habeas corpus, to have the body, is a writ issued to enforce the fundamental rights of individual liberty against unlawful detention. Through this writ, the Supreme Court or High Court orders a person who has arrested another to bring the body of the detainee before the court. The Supreme Court or High Court can issue this writ against both private and public authorities. However, it cannot be issued when the detention is lawful for contempt of court or legislature by a competent court or outside the court's jurisdiction. Now, the next is mandamus. The writ of mandamus, meaning we command, is used by the court to order a public official who has failed to perform their duty to resume their work. It can also be issued against public bodies, corporation, inferior courts, tribunals, or the government for the same purpose. Mandamus can be issued against public officials, public bodies, corporation, inferior courts, tribunals, government. आपको याद रखना है. Cannot be issued against to enforce departmental instruction without statutory force, to order discretionary work, to enforce contractual obligations, against the president or state governor, against the chief justice of a high court acting judicially. The next is prohibition. The writ of prohibition, meaning to forbid, is issued by a higher court against a lower court to prevent the latter from exceeding or usurping jurisdiction it does not possess. Okay, it directs inactivity. समझ गए? Prohibition मतलब inactivity हो गया कि आप अब आगे नहीं बढ़ सकते हैं. ठीक है? To lower court. Prohibition can be issued against judicial authorities. Prohibition cannot be issued against administrative authorities, legislative bodies, or private individuals or body. The last is certiorari. Certiorari, meaning to be certified or to be informed, is a writ issued by a higher court to a lower court or tribunal. It orders them to transfer a pending case to the higher court or quash their orders on grounds of excess jurisdiction, lack of jurisdiction, or error of law. Pre-1991, certiorari could only be issued against judicial and quasi-judicial authorities. Post-1991, it can be issued against administrative authorities affecting individual rights as well. It cannot be issued against legislative bodies, private individuals, or bodies. The last is quo warranto. Okay, quo warranto is meaning by what authority or warrant is issued to prevent illegal usurpation of a public office. The court inquires into the legality of persons claimed to a public office through this writ. ठीक है. Quo warranto can only be issued for a substantive public office of a permanent nature created by statute or the constitution. It cannot be issued against private or ministerial office. This writ gives the right to seek redressal to any individual other than the aggrieved person. Now let's see the difference between the power of writ jurisdiction between the Supreme Court and the High Court. Supreme Court uses this to enforce fundamental rights, whereas High Court can also use it for other legal rights. The jurisdiction of Supreme Court is throughout India, or High Court can be within territorial jurisdiction or where cause of action arises. Power, Supreme Court cannot refuse to exercise writ jurisdiction है ना, for fundamental rights. For High Court, it's discretionary power to refuse writs. Okay, with this, writs also is completed.